Good morning, everyone. Welcome to our Employment Law Update webinar. It's been well over a year since we did our last one. I'm just waffling for a few seconds while everyone makes their way electronically into the session, so we won't start quite yet. I've got an employment law update to give, and I'll be dealing with that. We had a last-minute emergency when I heard that Catherine Dacres, who was going to be doing the first talk, wasn't feeling well this morning. So you've got bonus me for the first half hour or so on the employment law update. After that, we're going to have a discussion about resolving conflict in the workplace, which is a massive subject, and extremely conscious that almost everyone who's going to be on the session, all of our guests, will have done this far more often than I ever have. But that's the beauty of being an employment solicitor. You don't have to do these things usually, but you tell other people how to do it all the time. So if I had more of an opportunity, I'd ask everyone who's a guest on the session this morning to give me advice. But you can join in as we go along. I think you're forbidden by the particular platform we're using to either show yourself or to talk. But you can raise questions through the chat box, and we would like to have questions. And while I'm going on and giving my talk about employment law update, do feel free to raise questions. And I'm hoping that Waleed and Steph will look at the questions. They'll notice them more than I do as they flash up, and they'll trip me up and make sure that I answer them or have a good go at answering them. I'm joined this morning by Waleed Tariq, who's a solicitor in my team in Worcester. He joined us in February this year, and he's going to talk a little bit later on. I might ask him to interrupt and to help me on the really difficult legal questions during the session that I can't answer. That's my standard lawyer's joke at this stage. And Steph Hallett is our head of Eagle HR, our internal HR consulting business, and she's going to take a larger part in the discussion later on about resolving conflicts in the workplace. And so you'll be hearing from her later on, other than her interrupting me to say, Michael, you're not answering the 10 questions in the chat room. So if we could have the first slide, please. So you've got me rather than Catherine. I've done my revision. Everything will be fine. You can ask questions. The most complicated bits of last minute revision that I've done this morning are about new pieces of legislation, most of which are not in force at the moment. So I've got a little bit of leeway, but I'll try to make sure that I give you a nice flavour of what's coming. The legislation I'm going to talk about is in effect because it's received the royal assent, but I think that none of the three particular pieces of legislation I'm going to talk about are actually in force at the moment, and I think all of them are awaiting regulations before we know exactly how they're going to come into play. If we could have the next slide, please. So don't be too worried about that first heading, administration. I just want to mention on the next slide in a moment the sort of passing of Wilco. It's for employment lawyers, it's just a news item that we notice more particularly, not just because they live next door to us in Worcester, but also because it raises issues of redundancy consultation. And obviously you're all much more interested in redundancy consultation in the sense of being a living company, a living organization, a living employer that may occasionally need to consult with employees in some way or other. And I'll touch on that briefly, but it's not a talk about the details of redundancy consultation. It's just something to discuss that uses the Wilco story as a bit of a hook. I'm going to talk about post-termination restrictions. There is a case to mention, but principally what I want to talk about is some proposed legislation that the government announced in the spring this year about non-compete clauses and how it might want to restrict them and keep them to a minimum. And I want to talk about if that happens, what do we do about it if we're thinking about it from the point of view of the employer? You know, why is it coming in? Why is it relevant? What difference does it make to us? So I won't talk about the case very much because they're never very interesting legally. The law has been unchanged for years and years, but factually they can be quite compelling. But it's just another hook, so I can talk to you about post-termination restrictive covenants and what to do about them. There's an interesting pair of pieces of legislation about flexible working, which I'll talk about. They're at different stages, and I'll go through those. Some family-friendly rights, and I'll deal with at least three pieces of legislation in relation to that. But obviously, in the time allowed, I'm going to try and stop myself at 10 past 10, unless something very badly goes wrong, or in case I get lots of questions, of course, that would be fantastic. Although not about the family-friendly rights, please. What I'll do is just take you through the main points about them, how they either dovetail or work alongside existing legislation, but there's nothing startling in them, but it's worth noting, and it's yet another thing to be aware of from an HR professional's point of view. Inevitably, I've got something about holiday pay because I've been looking at this subject for years and years and years. And there's been a big case in the Supreme Court in the last few weeks called Agnew, which I'll just talk briefly about. And I'm on a promise not to go on too long about it, because I could just talk for hours and hours and hours, and that's not an interesting webinar. But I'll just tell you what it means in practical terms for employers right now, rather than the exciting history of holiday pay disputes over the last 15 or 20 years. Okay, so let's have the next slide, please. Okay, well, we all know that Wilko went bust, and it was a fairly public event, and we can all see shops that are closing down or being taken over by other people. Why is that interesting in employment law context? Well, when there is an administration of that kind, and there are dismissals, as there have been in that case, that is an enormous, sort of publicly obvious failure to consult about redundancies. I'm guessing that it is always feasible that Wilko's, while they were desperately trying to find more money to keep going, were at the same time in parallel carefully consulting with elected representatives or recognised trade unions about potential redundancies. But I reckon that's about a 1% chance, because that's not what you're concentrating on. If you're the management of Wilko in that situation, your main aim is to survive rather than to plan for not surviving in relation to the employees. And so I want to talk just for a couple of minutes, just to remind everyone about what the basic consultation requirements are and what the penalties are, so that you've got those in mind. But I'm not going to talk about the sad demise of Wilko or any other high street store. There's one interesting legal point about having a chain of shops going bust effectively, and what that means in terms of the duty to consult, but I'll come on to that in a moment. Overall, any employer, if it's proposing to dismiss by reason of redundancy 20 or more people, employees, within a 90-day period, is under a duty to consult collectively. It can do that in one of two ways. It can either consult with a recognised trade union, if there is one, whether that's for a whole workforce or in relation to a particular part of the workforce. So if there's a recognised union, they have to consult with the trade union. If there's no recognised trade union, or for groups of employees where there is no recognition of a trade union, where there's some recognition elsewhere, there have to be elections of representatives to carry out that consultation process. And the consultation is meant to be about a number of things: the way in which the redundancies might happen, ways of trying to reduce the numbers involved, ways of trying to reduce the impact on those involved in a potential redundancy situation, the terms on which it's all going to happen. So in practical terms, for example, you might talk to the elected reps or the trade union about redundancy selection methods, the criteria that are going to be used, the payments that are going to be made, whether pay in lieu of notice is going to be paid, or whether it's notice is going to be worked. Obviously, elected reps are not, they can be trained. In fact, we ought to train them. Steph and her team, they're just perfect for coming in and training elected reps about particular consultation rights, redundancy or otherwise. It's my first advert. But trade unions, obviously, much more, that's their day job. If you've got a trade union recognised at a workplace, then they know how to consult and they know how to give you a hard time when you're trying to talk to them about possible redundancies. And in fairness, the whole point of that regime is to try to help employers not dismiss so many people for redundancy. That's why that legislation exists. And it's survived over many, many, many years through all types of government. There have been tweaks to the obligation. There haven't been tweaks to the penalties over all the years, as the potential maximum penalty for failure to consult about collective redundancies, that has got to a starting point of 90 days gross pay per affected employee, and has stayed like that, from when I was a union solicitor years and years ago. So the protections haven't reduced over many years, whatever government has been in power. It does come from a piece of EU legislation, an EU directive, which is one of the reasons why it has survived over all those years, that it wasn't really in the power of governments in the UK to remove the duty to consult and the remedies. They could fiddle around the edges, but they couldn't remove it. And of course, now we're in post-Brexit land, where every so often there's an indication that the government is going to have a bonfire of regulations and subject to international treaties and their own promises in manifestos. UK government can seek to change the law now in relation to collective consultation if it wished to, but that's subject to, that proviso is massive, because if you've made a deal with the EU that you won't drastically change employment law rights in the UK in order to get a nice trade arrangement with the EU, then this law could be around for quite a long time. I've never been against it. I think it's a good discipline for employers to really check that they need to make that many redundancies. Consultations meant to last for 30 days, unless 100 plus people are going, in which case it's meant to go on for 45 days. The penalty for complete failure to consult is 90 days, which is based on the old maximum period of consultation. So that 90-day maximum penalty has survived, even though the requirement to consult for 90 days before giving any notice of redundancy, that 90 days penalty is still there. That's if you do nothing as an employer. Go back to Wilco to finish this brief revision exercise on collective consultation. In their case, if they did nothing about consultation, as may well have been the case, then the starting point for any protective order is going to be 90 days. And then in a solvent situation, the tribunal would count down from 90 days to reflect how hard you tried as an employer. Insolvency is no excuse. There's a case, an old case, that says that insolvency is not a good excuse. There can be good excuses that you really don't foresee, but they've got to be pretty surprising. There are not many special circumstances defences that actually work. So, and if you're an HR professional and someone's asking you the question, we're thinking of having some redundancies, there won't be special circumstances because there's time to ask the HR team what to do. So that's not completely 100% correct, but you get my point. Can we have another slide, please? Right. Post-termination restricted covenants. There's a case mentioned there, just to have a case in there. Boydale was a case involving a 12-month non-compete clause, so a clause in the contract of employment of a very senior employee at that company with a lot of knowledge about its business, a lot of secrets. and they had a suite of covenants, and one of the covenants was that for 12 months after Boydell left the company, they wouldn't take part in the competing business. They wouldn't work for a competitor. And the law is the same as it's been for years and years and years, which is that based on Victorian law about restraint of trade, restrictive covenants start off being void as being against public policy. That's a starting point. But they can be enforceable if they are reasonable and go no further than is reasonably necessary to protect the legitimate business interests of the employer. That came out nicely. That doesn't always happen. But so that if you've got something that is worth protecting as a business, then you can put something in the contract and have reasonable confidence that it's going to be upheld by a court. But having a 12-month restriction it's not at the top end, but it's pretty much at the top end of of the sort of period you can have for any restrictions in a set of restrictions in a contract of employment. And that's partly because a court, if asked to look at covenants, will look at the respective bargaining positions of the parties. So Boydell may have not been in a great bargaining position when he got the job with the company, and so they give him a bit of leeway. If I change the example completely, and we're talking about a big business sale, and the shareholders of NZP Pharma Limited are selling their shares to a buyer, and all the directors of the seller have made loads and loads of money, and they're going to get a pile of cash from the buyer, then in that commercial agreement, that sale of the shares or the sale of the business, then they might be locked up for 3 years or 5 years. And that would be reasonable because they're getting a pile of cash. And so, they're entering into a commercial agreement with their eyes open. Whereas in this case, Boydell, he's only an employee. He's a clever one, and he's got lots of knowledge. And over the time when he was with the business, he picked up a lot of secrets, and so they felt they needed that protection. Anyway, cut a long story short, he said he was going to go and work for a competitor. He was going to say that the covenant was too wide, wasn't enforceable. It's quite a brave call on his part, but you've got to say it if you're him, having signed the contract. And they went to court and got an injunction. So a judge looked at it, and on the basis of the evidence, not a full trial, but just what the parties were saying had been going on, they said no, for that person in that situation at that employer about that information and those secrets at his level, 12 months was okay. Right, that's quite unusual. To be honest, full reported cases on post-termination covenants are themselves quite rare, because normally lawyers thrash this stuff out between themselves without going to the judge. Upholding a 12-month covenant, that's quite rare, but not ridiculously rare. Otherwise, you wouldn't see 12-month covenants in contracts of employment. But 12 months for non-competition, that is quite noteworthy. Right, why am I talking about that? Because it's not of everyday interest to most of my clients. It ought to be for some, but not. It isn't. Non-compete restrictive covenants. The government's got an idea that it's going to, or got a plan, which announced in the spring, to restrict non-compete clauses. So clauses that say, I will not compete with you after I leave your business in the sort of business I've been working in, doing the thing I've been doing for you. They're planning to limit that to 3 months after termination. And that would change the landscape as far as non-compete clauses are concerned. Bear in mind that there's a whole range of other restrictions that employers routinely put into a properly drafted suite of covenants, like not dealing with the people they used to deal with, not poaching employees, not interfering with the business of their old employer with the customers. There are all sorts of covenants that are much more likely to be enforceable in a contract of employment than the non-compete clause. The non-compete clause is the one most likely to be found in restraint of trade, because the nation, the trading nation, as a matter of policy, wants people to go off and work and get jobs elsewhere and set up on their own and trade and make money and employ people. So it's a public policy to be like that. So that's why the government's only looking at restrictions in relation to non-compete, so just not being in the same business. So what does that mean then? Nothing's happened so far, so there is no law like that at the moment. What might happen right away is that people might start arguing, I think they already have, that if someone is trying to uphold and rely on a longer post-termination non-compete clause right now, so in a dispute between an employee and a soon-to-be former employer, they might say, well, the government's going to change the law because it thinks that 3 months is the most it should be. And so that must affect how a court would look at reasonableness. So the government thinks that 3 months is what it should be like, then that must be an indication of what is generally reasonable. So the courts ought to pay attention to that. Yeah, I can see that argument being run. I don't necessarily see a court accepting it, but it's going to come into play. It might come into play in a practical way, just negotiating new contracts of employment. Someone who is a senior-ish employee coming into an organization might look at the covenants and feel more confident in saying, I don't want to agree to 6 months non-compete because the government's going to change the law, so why don't we make it 3 months now? To which you should say, let's leave it at 6 months, and then if the government changes the law, that'll be fine, thanks very much. What should you be doing anyway? Well, look out for that law actually changing. You should think about the other clauses in the contract to make sure they work. So I'm saying that non-solicitation, non-poaching, non-dealing clauses, they're not affected by any of this, and they're already more likely to be upheld by courts. So concentrate on those. If you've only got a non-compete clause in the contracts of your senior employees, your contract's wrong. So you've got to change it. So I'm always saying, because that's my business, look at your contracts, review them, make sure they're up to date. You'd be shocked at how many cases get to court and the restrictive covenants are nonsense. They're just really badly drafted. They don't even make sense in English, let alone legally. And I see clauses all the time that are very limited and clunky, and you don't know what they mean, and the defined terms haven't been defined anywhere. So it's always worth reviewing your restrictive covenants. Another thing to bear in mind here, notice periods. So if you're only going to be able to stop someone competing in your business, in your sector, for 3 months, maybe if the government passes this legislation, think about the notice period, think about garden leave. If you dismiss someone and put them on garden leave, they're under your control during garden leave. You can stop them doing anything apart from watch Cash in the Attic for 3 months or 6 months. And that's complete control. That's like a covenant. It's better than a covenant because it's definitely enforceable. So you can still get quite a lot of protection. So what you have to do is talk to, the people at the top, unless you're one of the people at the top, of course. Talk to yourself if you are, and just sort out what protection do I need in relation to which jobs, which people have become incredibly important to me, or which job roles have become more important to me over the years, so that I need to protect the organization from losing them, and try and give myself a nice cushion. How long will I need to make sure that that person's influence and contacts will be neutralized by the end of their notice period plus any reasonable restriction period? So it's it's like one of the things you should build into your routine every year. Check the contracts, who's been promoted, are they on a new contract, have they got covenants, should they have covenants? Always worth thinking about whether you should tone down the restrictions in a contract. No employee will ever hate you for doing that. It might make your covenants more enforceable. Or you might want to keep them looking nice and long and scary because cases don't normally go to court. And you can at least say, I'm going to enforce those, I'm going to go to court, I'm going to get an injunction, you're going to be off for 12 months, you won't be able to compete, we'll come and get you. So there's lots of little decisions to make there, but the main point is keep everything under review. Okay, can I have the next slide, please? Right, flexible working. It's going to be a day one right. It's this change in the law started as private members bill. That's a theme for several of the bits of legislation we're talking about today. The government's quite busy with stuff, Brexit, COVID, internal stuff. So it hasn't really been concentrating very hard on employment law, which used to be a really popular angle for all governments of all colours. Terribly political area, but in the last few years, employment law has been very, very much on the back burner, apart from furlough. Apart from what on earth do you do about COVID, then it becomes interesting, and no one knows what furlough is. But otherwise, in terms of reforms, it's all been quite quiet. But if things ever do settle down, employment will sort of come to the boil a bit more. So flexible working, day one right. I remember when flexible working first came in, when I was a union lawyer, we thought it was hopeless. We thought it was rubbish. It was a right to ask nicely and be refused for reasons given in the legislation. We thought it's hopeless. That's never going to work. And we were right for a bit. COVID changed everything, because that was a massive flexible working experiment, wasn't it? So now everyone wants flexible working. The law is developed so that ordinary flexible working requests have to be dealt with quite carefully, because people do run claims, and tribunals are willing to look at the nature of the reasons behind the refusal, if there's going to be a refusal. And whereas initially it wasn't thought by clever clogs like me that would actually happen, but it does. So tribunals will look into the sort of good faith, if you like, of the reasons for not giving someone flexible working. And anyway, flexible working requests often overlap with requests that are based on some protected characteristic, returning from maternity leave, someone with childcare responsibility. So flexible work, or with dependents to look after, someone, a disabled family member, or their own situation. So and it's wider now. You can ask for flexible working for any reason. So it's going to be wider still, because it's going to be a day one right. And I don't even carry in my head how long you have to wait at the moment, but you won't have to wait at all once all this comes into effect. I'm just having a look at when they're estimating it's going to come into force. We've got the Royal Assent in July 2023. It could easily be the spring of next year before it's actually in. ACAS are producing a new code of practice on dealing with flexible working. The law is also changing so that the employer will be able to make 2 requests each year instead of just 1. And the employer's got to deal with that request within 2 months, not 3. That will be the law when it comes in. There's some research the CIPD put out, which you may well have seen. 6% of employees changed their jobs last year specifically because of a lack of flexibility. That's interesting. I don't know whether it's actually completely accurate. How can I know? But it's. I think flexibility is expected much more, and I think because of I think it's all part of the Great Resignation, isn't it? It's the same thing. COVID made people think about their working arrangements. They could see that they could work in a different way, and now they don't see why they shouldn't work flexibly on an ongoing basis. So employers have to try harder to justify not agreeing to those things. Flexible working is important. Before I move on, there's a bit of legislation I hadn't put in here, which I could have referred to as inflexible working. The predictable or the Workers' Predictable Terms and Conditions Act 2023 has been given the royal assent. Another private member's bill. So an individual MP has thought of this. It's there, Friday mornings they make their argument, and the government has adopted it. That's how a government that's busy on other things makes changes. An MP makes a fuss, puts through a private member's bill, or tries to. The government picks it up because there's a danger it might get passed in a way that they don't like, and so they adopt it, and then and now we have this particular piece of legislation on the statute, but not yet in force. Again, ACAS are producing a code of practice about how it's all going to work, and there's going to be a qualification period, 26 weeks, after which an employee can make a request for a more, effectively saying to make their working pattern and working hours and arrangements more predictable. so less flexible for the employer. So there are lots of people who are in the work, in the workplace generally in the UK, who don't know when they're going to be working exactly from week to week, from day to day, from hour to hour, sometimes even. And so this legislation is to try to give them some protection when they've been somewhere long enough to not to be thought of as an emergency bit of cover. There's an exclusion for someone who's on a fixed term contract for less than a year, because it's deemed that if you're on that sort of arrangement, complete flexibility for the employer is sort of assumed. So you're not protected by this legislation. But I think it's sort of left over from the 0 hours contracts business from a few years ago. Right, family friendly rights. Now, these are a part of a sort of ongoing process of building up rights under this heading of family friendly that's been going on for years and years and years and years, and it's become I think it's just expected now that gradually, as society changes, first of all, people start to notice unfairnesses in corners of the world of work, or in some cases, things that were deemed to be just part of life start to be recognized as problems that ought to be addressed in some way. And these are three examples. Now, part of me is really reluctant to sort of go into the detail of any of these very much, but if I start with the Neonatal Care and Leave Act, as it now is, 24th of May, got the royal assent. It's not going to come into force until April next year. There are going to be, well, there are no regulations yet. So classic, again, situation, the government sort of brings in a right. It's not a criticism, this is how it works. We know this. You bring in an act that says there are going to be some regulations saying this in broad terms. And then when the regulations come in, we all know what the actual practical on the ground effect is going to be. But we know some of the things that are going to happen. It's not a political matter. The various parties have suggested this. It's been recognised that if a baby requires neonatal care, then extra assistance is going to ought to be offered. It's for the good of the worker. It's just a recognition of something that can be unfair otherwise. I suppose one practical way of looking at it is that you have your whatever maternity rights you have, or parental leave, or all the rights that existed before. But if your initial period of parenthood is affected by an acute medical crisis for your new baby, then effectively part of the benefit of the maternity period sort of disappears. And this legislation is in part intended to redress the balance. It gives up to 12 weeks of paid leave if the criteria that are eventually going to be published are met. And it's anticipated that will be taken at the end of maternity leave period. So that's going to take a bit of thinking about. So effectively, you don't have to know. You can imagine why this is. You don't have to sort of define at the moment the baby's in a crisis and the parents are worried to death. You don't have to think, oh, I must apply to my employer for some neonatal paid leave. You're already taking some leave that's protected by statute. Because of the nature of the situation at that time, as will be defined in the regulations, you will be able to take a bit more paid leave at the end of the maternity period. And it could easily be that someone will just take their parental leave, their maternity leave at the beginning, and then adjust when they're going to come back to take account of the extra 12 weeks. Why wouldn't you do that? So it's going to extend the right to paid time off after a baby arrives, and that's coming soon. Next year. Feels like a long way. It's not that long, is it? But I checked. I don't think there are any regulations at the moment. I don't think there's any code of practice, but there will be one. There's nothing specified at the moment about medical evidence. And that's a big deal, isn't it? That you could see that being a potential issue. As employment lawyers, we're nice people, but we always think of bad people and how they might exploit situations. And so how do you know if there is a situation that might give rise to this right? So we'll await the regulations, we'll await code of practice, and so on. Okay, got to accelerate somewhat now. Carers, the Carers Leave Act. Again, it's had the Royal Assent in May this year. No regulations yet. We don't know how this carers leave is going to be taken, but effectively it's a right to a week's unpaid leave per year for someone who sort of fits the criteria. That is, if someone has a dependent with a long-term care need under the criteria set out in the Act and in the regulation. So if you're a carer and it's just a long-term situation, then you're going to have to, as employers, HR professionals, and I'm going to have to think about it as an employment lawyer, bear in mind that someone could take a week off each year, unpaid, just for that purpose. And it may well be that it's going to be in full days or half days, or up to a block of a week. We don't know yet, but it's coming, and so we need to look out for that happening. I mean, the fact is that at the moment, we think that the regulations may not even require the employee to supply evidence. I don't know if that's going to happen in that way, but that's a possibility. And again, for the skeptical employer or the worried HR department, that's an issue. There's a question. And I'm just trying to get into it so I can see it. Where's my mouse? From Julian. Will it be applicable respectively babies born in, say, mid-March 2024, acute care? Let's have a look. I can see if I would have done a tremendous last-minute revision job if I knew the answer to that. I don't even know if I am meant to know the answer to that. But I think that, bearing in mind that the legislation isn't likely to come into force until April 25, I'd not expect, I don't know, but I wouldn't expect that to apply to the situation that you described, Julian. Okay, if I'm wrong about that, I'll find out where you all live and tell you. So if there's something I don't know that is capable of being known right now, I'll tell you all about that. Yes, sorry. Oh, right. Okay, you've got the next message about 2025. I think the same issue arises and my same answer arises. I can't see anything at the moment, but if I'm wrong about that, I'll tell you all so that we know. Well, if we do know exactly what the cutoff is going to be, I'll tell you. If it's clear now, I'll tell you all and apologise for not knowing straight away. Okay, but thank you, Julian, for that. Right, what else we got? Carers leader protection for redundancy pregnancy. Now, all I'm going to say about this, because I'm marching on, time is marching on. Protection for redundancy pregnancy already, and as a matter of public policy and something we're all very familiar with, and it's, there's been protection for pregnant women and then women on maternity leave and then people coming back from maternity leave of various kinds. And why does that exist? It exists because historically bad employers were bad and did bad things to good people for the wrong reasons. And over the years, the view of society about how reasonable that was to have law that allowed those things to happen has changed, so that the law has caught up with that, so that now it is recognised. I think it's fair to say that pregnant women and women on maternity leave and returning from maternity leave, they have enhanced rights in certain respects, but that's only because they are much more likely to be treated badly by employers on average. So no one on this call, no one on this session, of course, But we've all come across situations where, there are just bad people around. And so our law is sort of drafted on the basis that people aren't going to be enlightened and they're not going to think about it in anything other than a completely commercial way. And if one was allowed to be completely commercial, then the law would be as it was 40, 50 years ago. But we're not, that's not how it is now. So what's this new law going to say? Effectively, all it does, what it's likely to do, because we don't know a massive amount in relation to this, and because it hasn't been in operation very long, those who are returning from pregnancy, or they're pregnant, they're in a protected period of pregnancy, that's likely to be when the employee tells the employer that they're pregnant. So we think that from that point they're protected. An employee who's recently had a miscarriage, someone returning from maternity leave, someone returning from adoption leave, returners from shared parental leave, those are the people who are going to be protected. The regulation is not coming into force until April 2024. So we know who's going to be protected, and they're going to be offered a right not to be made redundant, but to be offered some suitable alternative vacancy. So it's an extra enhanced anti-redundancy right for people affected by the arrival of children. But just think about it in that way. And when the regulations are published and when we know exactly what they're going to say, we'll put out information to all our contacts about that. You'll see it everywhere. But effectively, there's another little bit of protection to add on to the other bits of protection at the moment. Simply because as time goes by, you see more situations where protection is needed and where the legislation that's come in doesn't quite cover everything that people now think should be dealt with. So there's nothing to do right away, but you can start planning straight away, and that's. I don't think it's going to change the mindset of HR people, because we're already thinking in terms of being super careful about pregnant and people coming back from maternity leave. And so it's just a slight extension of that, and guidance later on from us and from others, and from ACAS, for example, is going to show exactly how far that extra protection goes. Okay, have the next slide, please. Right, this is the bit I just is in my head, but I'm almost out of time, but that's okay. I'll just talk through this and then we'll move on to the discussion about how to deal with phones that ring at the wrong time. Oh no, it's about difficult employees and how to deal with conflicts in the workplace. Right, holiday pay. It's been around for years and years and years as a problem. Where does it start? It starts with working time regulations. They stem from the Working Time Directive, a health and safety piece of legislation from Europe to make employers give employees holiday paid at their normal rate. And that's turned into the working time regulations in the UK. The working time regulations are more generous than the old, I call it the old now because we're post-Brexit, the Working Time Directive. The number of days we get in working time regs, 28 days for a full-timer, 20 days in the Working Time Directive. So the European law applies to 20 days. UK law applies to the whole 28 days. What's the problem? If I give you a couple of examples, pilots at BA years ago were paid a flying allowance. They got their basic pay, which is limited, and then a flying allowance when they flew the planes. That was their job, to fly the planes. And when they took their holiday, because of the way UK employment law was drafted about what a week's pay was, they only got their basic pay when they went on holiday. They didn't get anything that reflected the fact that they got paid masses of money for flying planes when they were doing their normal day job. And they took that to the European Court of Justice, and the court said, that's not right. Your normal pay includes your flying allowance. So when you're on holiday under our directive, for those first 20 days, you get your normal pay, and your normal pay includes that allowance. Another case that went to the ECJ, Locke and British Gas, a man was selling gas appliances, machines that use gas for commission. So he got a basic salary and commission for selling the things. But when he took a holiday, he only got his basic pay when he went on holiday. He went to the ECJ and they said, yeah, that's his normal job. That's the pay he gets for doing his normal work, that commission. So that's got to be taken into account when he takes a holiday under our directive. And so cases followed, cases about overtime. Some of them I lost myself personally. Since I've been on the respondent side, I've sort of won cases when I was on the other side. The law always works on this subject. It gradually favors employees. It just does. I don't say that in a bitter and twisted way. That's how it's operated over the years. So overtime of various kinds, that is part of normal pay. There might still be arguments about whether call-out allowances, sort of being on standby, with those, if something is part of your normal duties and you get paid for it every week, like a shift allowance, you work shifts, you get a shift allowance, that's your normal pay. Why would you not get that as holiday pay? That's what courts and tribunals would now say. So that's the way everything was moving. In 2014, the government brought in some regulations that limited the effect of a whole series of difficult decisions for employers about holiday pay, because they were pursued as deductions from pay claims, like Wages Act claims in old money, Truck Act claims, I'm not getting enough pay, I'm going to the tribunal. And there was no limitation period on that. There wasn't a limit on how far back you could go. There wasn't a 6-year limitation like there is in a breach of contract claim. So you could go back all the way back to the working time regs, 15, 20 years or more. So in 2014, the government passed regulations that only really took effect at the beginning of July 2015, limiting those claims for holiday pay 2 years. You could go back 2 years. This Agnew case in Northern Ireland, predated those regulations. So it's about it had been lodged before then, and they can argue about more than 2 years. So the Supreme Court, in a way, was dealing with what you might think is a bit of dead law, because the law's been changed so that you can only go back 2 years. What was Agnew thinking about? It was thinking about whether breaks between holiday payments, could they break a series of deductions? Because you can go back years and years and years in a deductions claim where there's a series of deductions. So if I don't pay you properly every single month for 20 years, you go back 20 years. That's the old law. But in this case, people took holidays at odd times during the year, and there might be quite big gaps, 3 months or more, between those holidays, between those underpayments. And the argument was always that that gap would break the series, and that would reduce the amount of compensation the employer would have to pay. Agnew said that's wrong. Now, why does that matter? Because I've just told you that the law changed in 2015, effectively, from the 1st of July then, that you can only go back 2 years with a claim of this kind. I think it means that if someone makes a claim now, they don't have to worry about 3-month gaps at all, even within that 2-year period. So they're claiming 2 years loss of holiday pay straight away, like the difference in holiday pay, I mean. But those regulations from 2014, 2015, they were always very suspect as far as trade unions were concerned, and lawyers. It was uncertain whether the government was entitled to make those regulations, to bring them into force. And now that Agnew has been heard in the Supreme Court saying there's no gaps of 3 months you have to worry about, so you can just look back as far as you were employed, even as far as the working time regs if you were employed back then. Now that that's been said in the Supreme Court, unions are much more likely to come forward and say, we think those regulations in 2014 were unlawful and invalid. And if they do that, it's open season again. Okay, I'm going to jump over the next slide because that's what the next slide says. So if you could just go forward, but I think I've said everything I'm going to say about that now. Okay, well, look, that's my phone interrupted, herd of cows coming behind me, dog barking, disrupted legal update. If, as I say, if I've discovered that I've misled you in some way and there's a bit of law that Julian asked a question about and I'm wrong about it. I'll tell you all. I always confess. But if anything arises from anything I've said so far, apart from that, me not knowing how to unplug my phone, email me anytime you like and I'll give you the answer. If it relates to today's stuff, if it's a nice, easy question, I'll do it for nothing. If you've got a fascinating case that's going to last me a year, I'll probably do that for cash. So that's the update. Now, we move on to keeping the peace, resolving conflicts in the workplace. I've gone on slightly longer than I said I would to my colleagues, but they're probably not minding that too much. I'm blaming the phone. What we want to talk about, and admittedly to people probably who are much, much more experienced than us dealing with this sort of thing in practice, is, I suppose, the issues that arise when there's a conflict in the workplace of some kind. And I don't mean a fist fight, I mean just ordinary, non-violent conflict in the workplace between peers or between big people and little people, owners and little employees, and how that can be resolved. And then what if it can't be resolved in certain circumstances? And obviously, Walid and I look at it from a lawyer's perspective. Steph, much more from an HR perspective, which I find particularly valuable, because as a lawyer, a lot of what I think about is what you can get away with. So what has worked in tribunals, and how you can get away with things if you need to in an emergency, because that's often the sort of question I'm asked, whereas Steph is much more set up to help you get it right in the first place, so you don't have to ask someone like me or Walid how to get out of a hole. So Steph's job is to help you walk around the hole. Walid and I are more likely to be telling you how to dig your way out if you can. Can we have the next slide, please? Okay. You all know that conflict in the workplace can be, anything from minor disputes, squabble about who's making the tea and why don't you talk to me every morning, and why wasn't I included in the cake run, to I'm going to make a claim, I'm going to call the police. It could be that all sorts of things arise at the workplace, and we've probably all had exciting conflicts that have either been resolved or not resolved over the years, and we've got nice examples. What you can't get around is that people don't always like each other, and that doesn't have to matter, does it? I don't think, I just don't. I mean, it's nice to have a working arrangement where everyone is a friend of everyone, friendly. That can't always be the case. Sometimes that gets more complicated, because if everyone is big mates, they've been working together for years, and there's a fracture, there's an argument, then the damage is worse, because it's like the end of a love affair. It's a relationship breakdown between friends. I don't mean a more exciting sort of romantic thing. I'm just talking about people who've known each other for a long time and fall out big time. From a selfish employer's point of view, you'd rather, in a completely unrealistic way, like people to be pretty robotic and professional all the time. That's not human nature, is it? What you're trying to do, I suppose, on an everyday basis, even if you're just thinking about your own team, the people you sit with on a daily basis and work with, is to try and maintain a nice working atmosphere so that there's never an issue. Because I think it's true that when I talk to employers who've never consulted employment lawyers, it's almost always because they're a relatively small employer and everyone knows everyone else, and it's just operated by someone who's pretty sane. I think that a good rule for avoiding employment lawyers and employment tribunals is just to act sensible as often as you can, and to manage people and to talk to people in a sensible way. And then mainly you don't have to talk to people like Steph, Walid, or myself, which is obviously everyone's aim in life. Taking early action to remedy misunderstandings. That's a lot of what I'm going to say, and I always say, is that you should manage. If you're a manager, you should manage. And part of management is to identify problems that you can see in front of you and to try and resolve those, not by having a massive procedure necessarily, but just by acknowledging it and trying to get to the bottom of it and seeing whether you can remove the cause of misunderstandings. The deeper problems, well, that happens. That happens either because people suddenly decide they hate someone's guts and they can't bear to sit next to them. Something has been said that for some reason has really cut someone very deeply, possibly unpredictably, possibly without it being intentional, or it could be based on something we'll come on to, which is having a bad manager, having a bad line manager, having a bad colleague, having a bad supervisee, having someone who comes in and bullies you about your bills not being paid, or have you done the bank reconciliation so far? Why not? I'm standing over that. I mean, what is the deeper problem? Other thing to say about that is, of course, problems can often come from outside. There might be home problems. So there may not be, the conflict might have been more likely to occur at work because of issues that are going on in someone's personal life that are nothing to do with their colleagues. They're not bringing their disputes with a colleague to work with them. They don't have a serious dispute with their colleague as a colleague, but they're having a wretched time at home, so they're just on tenterhooks all the time, and something can go wrong for them. We're going to talk about making acceptable, inverted commas, known to everyone. We're going to talk about that. And then, are there any bad actors? Is anyone acting in bad faith? Is anyone in the workplace just either being mischievous or worse, deliberately or otherwise? So I'm prepared to, I'm not judging anyone here other than by saying that I can judge their objective behavior and their objective effect on other people. I don't care whether it's deliberate or not, in a sense, as a manager. So but I suppose bad actors is probably one of a subcategory of that, which is someone who is who means it. Okay, so there can be accidental things that can be remedied. There might be things based on someone's personality traits, or maybe even a mental health condition that you have to be careful of. But if someone's just being bad because they're a nasty piece of work, then that's worth identifying at an early stage. So that's my that's the slide on the personality clashes. Can we have the next one, please? Steph, I'm going to make you say something. Because I've had enough of my phone and the herd of cows outside the window. Do you want to pick this one up just for starters, and I'll butt in?
Yeah, sure. Okay, thank you. So yeah, I think it's important for us to touch on what arises or what happens if disputes arise in one or more different ways. So I think from our experience, what we're finding at the moment is an issue in the workplace manifesting itself into a more serious dispute that becomes a grievance that you then choose to investigate, that off the back of that becomes another grievance or a disciplinary as a defence. So we wanted just to sort of touch on how you address that, and if one is more important than the other, and how we need to deal with the order of service as such. So quite often or not, a dispute can arise between two individuals, or it can manifest itself into a wider workforce issue. And it's knowing sort of what procedures we need to implement in order to address that, and whether something can be dealt with more informally or more formally, and whether that's going to solve problems or whether it's going to continue to make a mess. I think that informal resolution methods, which we'll come on to throughout the latter part of this discussion, can always be a sort of good way to address maybe an issue between two individuals, but when it becomes something bigger between rival groups, as listed on this slide, that's not always a solution. I think, Michael, have you got anything in your experience in terms of how we would sort of advise clients with completing grievances?
I think that you touched on something I mean, we've got it under heading of competing grievances, but you mentioned if someone is in the course of a disciplinary, say, and raises a grievance about one of the people who's complaining about them, or indeed the person who's investigating them or conducting the disciplinary hearing, and then there's guidance, ACAS guidance about trying to deal with that. Decisions have to be made and noted and thought about quite carefully about whether to interrupt one process to get another one out of the way. And sometimes it's unavoidable. Any HR professional knows that they're going to get stared at hard by a manager if they say, I'm going to stop that particular procedure and I'm going to look into the grievance that the subject of that disciplinary has put in, because I need to get that one out of the way first, and I might have to go to appeal on that one. And then once that's done, I'll know whether I need to carry on with the previous process or whether we can, and that is not welcome news to a manager. But I think that, well, that's just one of the perils of being an HR professional, I think, isn't it? You're often giving managers news they really don't want to hear, and you're trying to sell them the idea that there's a purpose behind spending an extra week doing this bit before you carry on with that bit, because otherwise it gets messier and messier and messier. And you could get a situation, if you don't at least look at breaking down procedures and splitting them off and dealing with one thing before another, where one of the participants just won't take part anymore. So, and one of the what you're always looking to do, I think, when you're when you're applying any procedure, whether it's a disciplinary or a grievance procedure or a whole series of them, is to get through the procedure. You just want to get to the end. I mean, I know that employees sometimes don't want to get to the end if they're in peril of losing their job, but from a management point of view, you just want to get through procedures. So if there's a slight detour that you need to take as an HR person in order to get back on track in the main process, that, you know, a week spent doing that and having a quick appeal, that could be time very well spent, because if you leave it, you just left an argument for them later on. They're either going to say that whole investigation was suspect, the whole thing was dodgy because you didn't look at the grievance about him thinking I was a bad person and he's never liked me because I'm a West Brom supporter. And, you know, if you don't do those things, you're more likely to get into trouble later on. But another thing that this leads on to, not necessarily in these slides, but we'll see in a moment when the slides pop open, and that's the idea of mediation. I think that comes a little bit later on. Can we have the next slide, please? Right. Okay. Now, not everyone is a good manager. People can be accidental bad managers. They might be not very good people. So managers can be the cause of problems just as much as the people they might be complaining about. Obviously, it's a rich vein of grievances and HR procedures. The idea of a manager being accused of bullying or harassment or discrimination of some kind, or just being a bit overbearing, or just being unsatisfactory in some way. So it's not I'm not uncovering a brand new area of you know, a factual situation that no one's ever thought of before. But I think thinking about the manager in a situation where you have a manager and a junior employee is worth thinking about, even if the complaint has come from the manager themselves. So if the manager is saying that employee is hopeless, I want you to discipline them, I want you to go through a procedure, it's always worth spending a few moments thinking, oh, it's that manager again. Or this is the fifth time they've had a problem with a junior employee at that level, or they can never seem to get on with women. Or so I think that from an HR perspective, not that you'd necessarily drop that bomb lightly. I think it's always worth looking at whether the person who's actually asking you to do something and to sort things out, they might be actually causing the problem. That's a big call, but it's always, you've got to have it in your mind, because you don't know whether the junior employee that the manager is complaining about is in fact the issue. The manager who is accused by several people of issues. Steph, you don't have to say anything right now, but the sort of example I'm thinking of is where, well, you could have a situation where several people come forward all at the same time and say something, or you have one person making a complaint and you as an HR professional are trying to find out from other colleagues whether there's anything in it. So they're effectively witnesses in the first one, but they might also turn into complainants. I'm not trying to make you say something here, Steph, if there's nothing for you to say, but are there other scenarios there that you can think of, or have you come across situations of the kind that I've described there? I bet people on the session have.
Yeah, most definitely. I think that we see a mixture of either, one person feeling a certain type of way, raising some concerns that are of a serious nature that we then take seriously to investigate by speaking to potential witnesses, or alternatively, a collective grievance or collective complaints are raised. And it's trying to sort of differentiate between whether this is a conduct matter, whether it's a personal matter, that perhaps is that a ringleader has sort of encouraged others to join in on. I think that this is where things can get quite difficult for you to be able to really just get down the facts and not get muddled into everything else that comes with investigating a way someone feels about something.
Yeah, I think that one of the perils of the HR professional sort of in a business, and we get it obviously at one remove, being outside of our clients' organizations, is that we can be seen as complicating the processes. Back to that one again. There's also a sensitivity problem, or the confidentiality problem. So if one supervisee makes a complaint and they say that manager is bad and he behaves badly to several people, you've almost got to talk to those other people. But in doing so, it's hard to do that in a way that you can control. You can say that everything's confidential and you don't want to, you're trying not to spread gossip and rumor, but you've got, depending on the nature of the allegations, you've got to or based on them, you've got to work out how wide you can go with your investigation. So you can think of an allegation that's so serious, so nasty, that if you mention it as a possibility to other people who may not in fact have that issue at all, that you're actually poisoning the well forever, and in a way that might be very unfair on the subject of the complaint. So I don't know there's a way around that other than to always assess, well, how serious is that? If the complaint by a supervisee is that someone is a bit overbearing in meetings, they're not bullying, they're just being, a bit abrupt, then that's a question you don't mind asking other colleagues about, because they'll answer your question probably, and they're not going to suddenly think, oh, crikey, he's capable of being abrupt, that's awful. Then that's not going to happen. On the other hand, if someone is saying, oh, that person is always making sexually charged remarks to me, and I think they might be downloading child pornography, I've just invented a ridiculously serious allegation there, combination of allegations. You wouldn't routinely just send an email around the whole team saying, oh, what do you think about that? We're just carrying out an investigation. So somewhere in the middle, between those two extremes, you're going to have to decide on how wide to go and how much to say and how much you can trust the other individuals you're asking the questions of, so that you can carry out a fair investigation and deal with the original matter in a fair way. Again, I mentioned bad actors there, aggression and passive aggression. I'm just mentioning this as another example of the person acting in bad faith. You're always hoping that your employees are just generally nice to each other, or just generally nice. They might have home problems, they might have personal problems, they might have work problems, but generally they can be polite to each other and everything's okay. If you've got someone who is either overtly aggressive, you've got to address that. That's probably no good. That's no good these days. But passive aggression, that's a much misused expression. I'm not going to define it in this session either. But someone who can manipulate the situation, who can say things in a way that don't sound aggressive, but they're they're always great on their colleagues, that they can make it sound as if their colleagues have done something bad to them when that hasn't actually happened, and that can be quite corrosive over a period of time. And I just identifying that as a potential issue that an investigation might uncover, and then you've got to try and deal with that. I mean, the actual answer to that is, I suppose, if you identify that that is what you think someone is like, and you make a factual finding and that that's what they're doing, then you have to tell them not to do it. You have to explain to them what's going on. You have to tell them not to do it, and then it might become a disciplinary issue if they repeat that conduct. That leads on to the next bullet point, which is working out who is actually the problem. That's the whole purpose of the wider investigation. Where we're talking about relationships and breakdowns, we talk there about imposed processes, say grievance procedures and disciplinary procedures. I mean, if you run parallel grievance procedures as a way of getting through the process and getting to the end and addressing everyone's individual complaints, have you actually resolved the issues in the workplace? You've got rid of the grievances, you've dealt with them, you might have acknowledged this thing and that thing and not upheld that or that, but have you actually solved the problem? Almost certainly not. So the investigations might be, they looked at positively, they're a way of bringing problems to everyone's attention, and it being a bit scary because grievances are being looked into, even if they're competing grievances. And when an outcome is reached, honour might be satisfied as far as everyone who is making a complaint is concerned, but probably what's required after that is a bit of careful management and management of what is expected of them in the future in order to avoid problems of this kind. So you're not sort of suddenly turning on one person saying you've got to change the way you act and then everyone will be happy. But just the manager, again, has to manage. That's almost the theme of all this. Managers manage. Part of management is to manage those relationships and make sure that they're working harmoniously. And if they're not, deal with them. And if they can't be mates, they can't be friendly in an ordinary kind of low-key kind of way, not besties, but just friendly enough, then you have to say to them what is a minimum requirement, and that is behaving professionally towards each other so as not to generate conflict. It's my sort of golden rule of what is expected of an employee. You know, don't mess everything up by misbehaving. But, you know, that's easy to say, isn't it? Right, can we have the next slide, please? Now, Steph, you lead. I'm talking far too much. Everyone thinks that. When might mediation be sensible? Because, I mean, some managers might think, what are you doing? I don't want to bring someone in from outside. Are you joking? That's going to cost me money. Why would I do that? Steph, why might someone do that in the right circumstances?
So, yeah, thank you. In the right circumstances, I think mediation can be successful in resolving disagreements around the workplace between two or more parties, I suppose. I think it's important to caveat that the process needs buy-in from both individuals if it were two people in the situation. So mediation wouldn't work if one party wasn't in agreement that they wanted to participate. It's obviously a facilitated type of conversation where an external mediator comes in and is completely impartial to the situation that's arisen, but it's sort of strong emphasis on the success rate being providing both individuals have bought into that process. I think it almost works when by trying to help the individuals understand the other's perspective and the other's perception of matters. So an example may be if there was a repeated issue around not being included in the cake run, using your example earlier, Michael, that's festered into something different, where that individual's then been left out from lunch invites, meeting invitations, valuable input into presentations, that sort of thing. So it's
what are you saying, Steph? What are you saying? Are you saying I cut you out of the preparation of this? I can't believe you're doing this in public.
Lived experiences. No, so Yeah, we've had a very recent example where two colleagues in the same department had a disagreement about not being included in a tea run in the kitchen, and it just turned into something awful. And our client had sort of run out of options. She had sort of exhausted her own input, and so we were able to help and bring someone in from Eagle that can mediate, and thankfully that's had quite a successful outcome, and the individuals are both within the business and are both working well together now. Of course, I'm mindful that it doesn't always work well, and it's not a solution for every disagreement or workplace dispute, but it's certainly one to consider for more of a low impact process.
Yeah, and that last bullet point about not being an imposed solution, you can't make it. You can't make them take part. Sometimes it can be an alternative to doing something worse and more serious. So if you've got two people who cannot work together properly, and you're going to have, and they're wondering about grievances, and that might happen, you can offer them mediation as an alternative to just letting them have a go. You know, put a grievance in, we'll run it, see what happens. We'll have to decide a winner and a loser. Is that what you want? Is it better to have some sort of mediation? Can be low level, can be a coffee around the corner in a quiet room, just talking through things. It doesn't have to involve an outside party, but that can help in some situations. Last one on this slide, because I think it's good. I think it's a good option where other easier options have failed. No good in a situation where I had a situation a couple of years ago where the dispute between the parties included one party saying that the other person was discriminating against them on the grounds of race. And until then, we were trying to think about mediation, but you couldn't insist on that in that situation. You can't say the person you think someone has been guilty of race discrimination towards you. I'm not going to make you sit in a room with them and try and make friends, because that's not a misunderstanding. That hasn't. I'm not saying it happened, but even the belief that something so serious, so worrying has happened, that it could be you could involve mediation, but you can't make them have it, and you couldn't, for example, put the alleged victim, the complainant, off from putting in a grievance by saying, "Oh, can we have mediation instead?" Because they're going to say you're not taking it seriously. So you have to tread very carefully. It's not always going to be right. Okay, got a couple more slides to get through, including a vital one from Waleed. So if you could you have the next slide, please? Sorry, I should have said that. Steph, I'm just going to run these really quickly because I want to get onto Waleed's slide, which is one of the biggies, really. We talked about timing of processes, when to hold sort of competing, complementary processes. Are they simultaneous? Do you have to do one before the other? Think about that. Who does what? That's literally, have you got enough people on standby to deal with the investigation, the hearing, the appeal? Are you working your way up the hierarchy? So, don't go in with the big boss in the investigation, because then everyone who makes the decision later on is junior to the first decision maker. You're shooting yourself in your foot if you do that. And I mentioned appeals on the same basis. So if there's a right to appeal in any process, make sure that the person who's dealing with the appeal has got the authority to make a contrary decision, and that can be seen, and that they're as independent as possible. Think about that right at the start. If this all goes wrong for me, have I got people in place who can deal with that? You could think about external people. So small organization, or you need to have someone quite senior because it's quite difficult or sensitive. You might go outside for someone to be a decision maker from outside. A range of people would be available to do that. Is the boss the cause? I sort of covered that earlier on. And confidentiality, of course, that's what you want. And not just in my crazily complicated, serious allegation from a few slides ago, but just generally, you want to make sure that if you're running a procedure, everyone is trying to do it in as discreet a way as possible so as not to worsen the situation. Okay, and that's leaving aside sort of data protection. You know, don't send the notes of the meeting out to the whole team or something by mistake. You don't need legal advice about that. So can we move on? Because I think we should have a good 10 minutes on this one, which is a biggie. And I like the picture you've chosen there, Waleed. Open door. So you go ahead.
Thank you, Michael. Yeah. So, yeah, I've entitled the side, "Does Someone Need to Leave?" Have you ever experienced a sort of situation where you're thinking to yourself, does someone need to leave? And I say that because this is a surprisingly common scenario that's coming up, and it can arise out of a number of sort of situations, some of which we've discussed earlier already, that my colleagues sort of mentioned. And one of those situations that sort of comes to mind is perhaps grievance procedure. So if an employee has raised a grievance against another employee, perhaps at a different level in the management structure, you know, such as a senior figure, HR may often find it difficult to sort of address such a grievance more often because that individual may have overall responsibility for the business. In such a situation, it's important to try and have somebody at least as senior as the person being complained of to hear the grievance, just for objectivity, and consider if it's feasible to appoint an external investigator to investigate and produce a report on the recommendations, where the complaint is against the only and senior most person in management, for example. So HR professionals, of course, may struggle to see what the remedial actions can be in that situation. What can they do to you know, take action against their own boss effectively? Now, it's important to consider the risks to the business in such a situation. In particular, what are the risks of taking no action? And this will, of course, depend on the nature of the complaint as well. Another sort of similar situation is where there's a disciplinary process, for example, and that's been commenced, but a proper process hasn't been followed for some reason because there's either some sort of procedural irregularity, or there's insufficient notice of meetings being given, or because a proper investigation can't be carried out because it's just going to take such a long time, or the issue is so complex that it will take a long time for that to actually resolve itself, and it's not feasible to keep someone in employment for such a period because they, I don't know, they pose some kind of a danger to the business, or some kind of concern that just simply cannot be kept in the office or place of work. Now, there can be situations where all of that actually happens together, and you've got a complete breakdown in sort of trust and confidence between employer and employee. And it's important to be able to map out a process in respect of that employee and each of the issues that have come up in question. So we talked about a grievance, we've talked about a disciplinary. It's very important that it's very clear to the employer what their sort of options are in respect to this employee. So if there's I've had a very good recent example where actually there are a multitude of issues with a particular employee. We're talking about a sort of very specific performance issue. We're talking about disciplinary issues where there are actually some serious questions about this person's conduct. And it's abundantly clear to the employer and the employee, and from the employee's behavior, that nobody really wishes for them to be there. And so one of the options in these kind of situations is to consider having a protected conversation with the individual or individuals in question. You may have previously heard of a protected conversation or a conversation under Section 11A of the Employment Rights Act. And this is in effect a conversation that's off the record, meaning it can't be referred to in certain types of subsequent claims, specifically unfair dismissal claims before an employment tribunal. Now, it's important to remember that this is limited to claims for unfair dismissal and may not extend or doesn't extend to other types of claims, such as discrimination, for example. And of course, the next natural step would be to make them some kind of offer to settle any claims they may have as well, to offer protection for the business. And we can, of course, advise on that further if that is sort of an irreconcilable situation that has come up within your business. And that's really sort of the crux of one of the key options that we find that we are exploring with a lot of clients in sort of the relatively recent past. Michael, Steph, I'm not sure if you've come across sort of similar situations, if you have any particular thoughts on what I've just mentioned.
I think there may be, I can't see who's on the call, but there are probably people on this call I've dealt with about situations where there's a complete breakdown in the relationship. And there's whatever the nature of the organization, even if it's a charity or a public sector organization, or something that an organization that isn't overtly commercial, there's still eventually a commercial decision that someone has got to go. Nothing we're saying is meant to cut across the rights of people who make complaints of certain kinds not to be treated badly because they've made those complaints. So but I suppose all we're talking about here are the thought processes that ought to take place before you then ask the lawyer, can I do it? Is there, or how can I get this? How can I sort this out? So if in the example that was given where it's the owner, and I've had cases like this where I'm talking to the individual employee, the owner is the baddie, the owner's done something unforgivable, they're going nowhere. They're never going to they're not going to sack themselves. So in that situation, the employee can threaten claims and run claims, but they're not going to end up working for that employer probably. And so they're heading for the door, and they're heading for a settlement, and that's what they're trying to achieve. From the employer's point of view, again, I've had experience of this, where someone near the top of the organization is being very bad, but they're going nowhere because the owners of that business are not going to move them. And so when someone makes a complaint about them and it's serious, practically that's only going to end in one way. So it's not going to end in the indispensable person put in by the owners of the organization going until something crazy happens. And so that doesn't mean to say that everything you do to the junior person is legitimate and lawful and risk-free, if I can put it that way. But practically, there are going to be situations where you're just being told they've got to go. That person can't stay here. And that can be, even if that's not for virtuous reasons, if I can put it that way. So if the ultimate reason is because the owner is saying that they've got to go, then however you achieve it, they're going to go. And the only question is how big the check is going to be when you part company. Sticking to the talk, that doesn't stop you going through procedures. You don't make things worse for yourself. If you're going to be in a bargaining position, a situation where you're going to have to make a deal with someone and have a settlement agreement, don't make things worse by failing to go through procedures, but have that side conversation. If it's a protected conversation of the kind that Walid's mentioned, then as he says, that's unfair dismissal protection, that's all right. But if you're in a big dispute, then you may have protection from without prejudice discussions as well, and that gives you a little bit more leeway. So I'm conscious that he's been given the hardest slide there because it's the biggest topic. It's the juiciest one from an employment law perspective, and it's the most difficult one, I think, from an HR professional's perspective, because bigger pressures than ordinary HR pressures are coming into play, and you have to make something happen that wouldn't happen naturally. Okay, next slide, last one, I think. Changing the culture, telling people what is acceptable and not acceptable. That's everyday HR work. If you have a workplace where the culture is poor and bad things are done on a regular basis, you've got to draw the line somewhere and make it clear. And when you've done that, everything after that, you can start from scratch. You can have a policy, you can say from now on, this is unacceptable. But if you do it by sacking someone, they could have some argument. So if they've done something pretty bad and you have just decided you've changed your policy and you pick on them and you dismiss them, they might have a claim. The person after you've changed the culture and you've made it clear to everyone what is acceptable, what's not acceptable, they will have much less leeway to say you've never done that before. If you make it clear, you've looked after the future for yourself. Next slide, we've got to finish, haven't we? Right, and this is the one I was expecting. You can't do nothing. Whoever's putting the pressure on, whether you're the owner manager, the big boss, the head of a department, or you're the HR team, you've got to manage, you've got to do something. And if you're running out of ideas, the people on this call and other people within our team, they can help. That's the purpose of situations like this. We've come across lots of different situations. Sometimes if you're in the middle of a difficult situation, you can't think clearly about it. You can't think whether a way is okay or not okay. Get some outside help, talk to your colleagues. HR professionals full of ideas, full of experience, full of brilliant solutions. If you haven't got access to that, you've got access to us. Don't fail to do something that doesn't solve the problem. Right, well, got through it. Thank you very much for attending. Any questions at all that arise from the things we've been talking about, you're more than welcome to send them to me. If you haven't got my email address, it's on the website. I'll find the right person to give you the answer. If it's about something we've spoken about this morning, have that on us. Thank you for attending. Look forward to doing this again, hopefully in person next time. Thanks very much for being here and for listening to all of us.